Right out the gate, the judge's patience is on life support. Notice that "why are we doing this" opening? That's judicial code for "I warned you, and you didn't listen." Anytime a judge references previous instructions this early, you know the courtroom tension is already at a 9/10.
If the court wishes
why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond, and now you want to go back, and you guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases, so they don't have to sit through this. I'm required to, and you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago. J Group Holdings versus Lazar Stafffield.
Good afternoon, Your Honor. Plaintiff Anthony may not be appearing on behalf of plaintiff.
Good afternoon, Your Honor. Lazar Stafffield.
Your interpretation.
Quick legal checkpoint: when an attorney mentions "reserve all documents," they're talking about preserving the full paper trail because something wasn't filed right the first time. In civil court, bad paperwork is like showing up to the airport without an ID. You're not going anywhere.
In this case,
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this instance.
the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Can you speak?
Was that?
Listen carefully to what the judge is doing here. She's narrowing the issue down to a single yes or no question. Judges do this when someone is dodging. It's the courtroom equivalent of "did you finish your homework or not?" No essays. No detours.
Done.
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again.
Here's the core conflict. The defendant keeps saying documents were served, but neither the judge nor opposing counsel has seen anything. In legal wars, proof of service is the ammo. No proof? No firepower. That's why the judge is escalating. This is procedural chaos.
The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption, and served them on opposing counsel.
Yes, we
My sole question to you is,
Okay.
did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it. But she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was,
Not by me, Your Honor.
yes. Okay, I see that. But that was not the original.
I have not seen that.
Service on here. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
May I show this to you?
No,
This,
we did the same thing.
no. This notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal.
And here it is, the plot twist: she tried to file a dismissal as if she were the plaintiff. That's like trying to fire your boss from the company you don't own. Judges hate this because it creates administrative headaches and legal confusion. You can feel the judge's internal scream.
Of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to...
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay.
that's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. That the backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than